and I have had a long time of working together in the area of religious liberty. Michael is an attorney, and he has worked in religious liberty. He has a website, I think that's what we call it, right? Okay. A website that I read regularly. It is well worth reading. He posts some really good information. Sometimes it's the kind of information that we need for our soul, and sometimes it's just about the news of what's going on in the world. I don't need to explain to you that things are going on in the world that are difficult. And Michael, welcome to Arlington, and welcome as we speak about some of the serious things that we face today. Thank you.
Be here this morning. I don't know if my microphone's on. How about now? Okay, there we go. I'm going to trip over this chair. It's good to be here this morning. You know, and I'm very happy to see Audrey Johnson here. She's a good friend of mine for a number of years. I first met her when I was at the Maxwell's house, and I was Religious Liberty Director here at the church, and Pat Maxwell said, there's somebody you need to talk to. And so I was at their house, and she put me on the phone with Audrey Johnson, and we began talking about religious liberty. And I'm so glad we've been able to have that friendship for all these years. A few years ago, about 2 years ago, she agreed to be a member of the advisory panel of the website. And I know that it's been a really good thing to know you for all this time, and I really appreciate you being here. A lot of other friends here today, too. It's always interesting coming back to your home church to speak. You know me from way back. Today we'll be talking about religious liberty, and I'm going to be taking you on a tour of history, beginning with the early church, going up through Constantine, the Roman Empire, the Reformation, the foundation of the United States, the formation of this nation, the Civil War, the Civil Rights Movement, and up to the present. And the reason we're going to go on that history is to talk about the tension between church and state that has existed throughout that time, and what is going on now, and what we can do. We're in a time in history where there are conflicting rights, where the rights of religious liberty may conflict with other constitutional rights. And we need to find ways to navigate that issue and to preserve as many rights as possible, even when they conflict. And I'm going to be talking a little bit later in today's service about a method that I think may work to address those types of conflicts when they arise. Romans 12:18 says, "If it is possible, as far as it depends on you, live at peace with everyone." Now, Paul was writing that from a position of an individual who had actually been actively persecuting Christians and arresting them and leading some of them to their deaths. He was there at the stoning of Stephen. He was a persecutor of God's people who ultimately became one of the chief defenders and expositors of the gospel. So when Paul is writing this, he understands both perspectives, that of the persecutor and of the people being persecuted. And he understood where people were coming from. And his answer was not to go to war, not to engage in a culture war, but rather to try to get along and live in peace. And Romans 12 and 13, if you review them and you go through those chapters this afternoon, point to his philosophy on how the church could interact with the world. Persecutions took place over the first 3 centuries of the Christian church. And the Roman Empire was a very interesting place because it had a very strong legal system, and the citizens had rights. But what would happen is the Christians were viewed by many as not being religious at all because they didn't have a God that you could see. They had an unseen God. And so the Romans thought that they were not religious at all, and they would persecute them and blame the Christians for various things that went wrong. Nero even blamed the Christians for when he actually burned down Rome. So these persecutions took place over the first 300 years, and they actually reached their peak between the years 303 AD and 313, which was over 2 centuries after the Christian church was formed. Laws were passed across the entire Roman Empire requiring Christian books and churches to be destroyed, and those who would refuse to recant their religion would lose their rights. Christian pastors were arrested and thrown into overcrowded jails, and some were executed in some areas, and some governors in other areas of the Roman Empire looked the other way because during the rise of Christianity, a number of Christians had actually rose to prominence in the Roman government, and then they'd been able to create good impressions on the judges and on the governors in those areas. But the years 303 to 313 were the most severe persecution that the Christians faced under Rome. But something interesting happened in the year 313. That's when Constantine the Great, who was 41 years of age, he'd been the emperor of Rome since 306, he suddenly converted to Christianity after he said he saw an apparition of a cross, and he marched his army through a river and baptized everybody and said, "We're now going to be Christian." So soon after he became a Christian, he actually instituted and called the First Council of Nicaea in 325, and that's when the Nicene Creed was developed, which is still one of the main documents that the Christian church uses. It talks about the life of Christ, where he came from, and his resurrection and his return. But the words of the Nicene Creed became not only the words of the church, but they also became the words of the empire. The church and the state joined together. And the combination of powers was in place throughout the Middle East, throughout the Mediterranean area, and up into Europe. There's nothing wrong with the creed itself, but that power of the creed actually took on a life of its own because the church and state were one, and the church could do whatever it could to try to use the power of the state in order to enforce its religious rules. As Lord Acton's truism states, power tends to corrupt, and absolute power corrupts absolutely. The idea of religious pluralism was fought against. Christians who had previously depended on having a personal relationship with the risen Christ suddenly found that the process of faith involved the government, and it involved the state and the church. Because what would happen is the church would put the emperor in place, and the emperor would do whatever the church wanted to, and if the church wanted to enforce its rules, it would go through the emperor, and people who were not towing the line could be put in prison or punished for breaking religious rules. The Pope ultimately claimed to be the successor of Peter, and he said that he held the keys of heaven and hell, and now all had to bow in allegiance to that system or face the risk of falling into eternal damnation. The state could rule your life, but the church could rule your eternity. That system remained in place for a long time, up until Martin Luther, John Calvin, and Huldrych Zwingli came forward in the beginning of the 1500s to challenge not only the authority of the church, but also the empire that was propped up by the church. One of the main things that Luther discovered was that the individual could stand before God and be saved directly. You did not need to go through the church. Both the government and the church saw that as a major threat, because if you no longer needed the church for salvation, then you no longer needed the government for salvation. The emperors and the kings no longer had that kind of authority to say that they were instituted by God to rule you. So it ultimately fractured the entire system of government that had existed in Europe. It tore down those walls that church and state together had built between the believer and God. And it restored the concept that had been lost to history that God loves you and nothing can separate you from that love of God. So in response to this, in 1542, the papacy reinstituted the office of the Inquisition, which had previously been put in place in order to make sure that the Jewish converts and the Muslim converts in Spain were towing the line when it came to religious orthodoxy. And they reopened the Inquisition and used it to go after the Protestant Reformation. If the concept of the authority of God being established in the church and the state could no longer hold sway through fear and subservience, then the church and state acting together would need to find other ways of ensuring compliance, and that would involve torture. By 1558, there were mass executions of people that the leaders of the Inquisition accused of blasphemy, anti-religious sentiments, disrespect to church images, mockery, and even eating meat on forbidden days. Torture was employed, but the Inquisition had a rule that torture was not supposed to cause permanent damage and was not supposed to draw blood. So they developed something called the rack, where they would put a person on the rack and pull them apart. Oftentimes they'd dislocate their shoulders, trying to convince them that they should conform with the church's teachings on various issues. They also invented waterboarding. And the Inquisition was in effect up until the 1800s, although it had largely ended by the time that Napoleon took the Pope captive in 1796. And around that time, something else was happening on the other side of the Atlantic Ocean. So you see the history of the church up until the year 1776, and that part of the history went through a number of radical transformations. Beginning, it was a small group of people, individuals personally knowing God. Then, over time, they were separated and they had to go through the system in order to be saved. And then you had the Reformation. It was constantly changing and transforming itself. And the question was, what are you going to do about the balance between the church and the state? Should church and state be together, or should they be separate? The founders of the United States were fully aware of what had been happening in Europe. And instead of putting the church over the state or the state over the church, which had led to bloodshed, uncertainty, and ultimately a suppression of the gospel, the founders decided to do something completely different. They decided to find a way for the church and the state to coexist to their full potential within their separate spheres of influence. Government on one hand, church on the other, separate, yet able to do everything that they needed to do in order to fulfill their separate missions. After the Declaration of Independence was signed on July 4, 1776, and the government was not yet formed, it wasn't clear that the colonies would even be able to work together, but ultimately they formed a federal constitution, and on September 25, 1789, Congress approved the 12 amendments to the United States Constitution called the Bill of Rights and submitted them for ratification to the states. The very first amendment said, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or of the right of the people peaceably to assemble and to petition the government for a redress of grievances." Now, all these are important provisions of the Bill of Rights, but I want to highlight something that's in that phrase. It says, "Congress shall make no law respecting the establishment of religion." A lot of people stop there and say, well, that just means Congress can't pass a law, but the states can pass laws. I'm going to get to that in a second. But looking at the construction of that language, it also says, "Congress shall make no law prohibiting the free exercise thereof. Congress shall make no law abridging the freedom of speech. Congress shall make no law abridging the freedom of the press." There are a lot of people who say, well, this just means that Congress should make a law regarding the establishment of religion. But if you look at the construction of the language, it also means Congress shall make no law involving freedom of speech, or petitioning the government for redress of grievances, or assembly. So if you say that states have the rights to make those types of laws, then you're also saying if you say that states have the rights to establish religion, you're also saying that the states have the right to institute limitations on freedom of speech, limitations on the right to assemble. And from my taking on this, and we'll talk about in a second, about how it's incorporated to the states, it means that Congress and the states don't have these rights, and that the states also cannot impose themselves upon religion. It should be noted, however, that the Bill of Rights as originally drafted up until the Civil War only applied to the federal government. Now you may wonder, why was it that the states did not have these rules imposed on them? Why did the Constitution originally only refer to Congress having these rights? And the reason is because there was something called slavery. And if the Bill of Rights had applied to the states from the beginning, then slavery would have been immediately illegal as a federal rule and as a state rule. And the fact of the matter was that slavery was a deal breaker for a number of the states joining the Union. Had the Bill of Rights applied to the states, a number of states would not have joined the Union. And it wasn't until after the Civil War, when 3 amendments were passed, that the Bill of Rights was ultimately applied, so that California can't establish a religion. California cannot, remove your free exercise of religion or limit it. The 13th Amendment, of course, was the amendment that prohibited slavery. The 14th Amendment required that all states abide by the Bill of Rights and that the Bill of Rights would apply to the states through its due process clause. I know it's a technical distinction, but it's very important because today, if you look at the way that jurisprudence is going forward, there's a principal amount of attack on the 14th Amendment, saying that the 14th Amendment was passed under gunpoint as a requirement for states to rejoin the Union after the Civil War. And they're saying that the 14th Amendment is illegitimate. In reality, the 14th Amendment is what preserves religious freedom from state overreach. And it's extremely important. And I get very nervous when people talk about the 14th Amendment no longer applying the Bill of Rights to the states. So you have the Establishment Clause and you have the Free Exercise Clause, and that's a two-part agreement that our founders made. One part said that government was not in the business of religion, and the other part said the government should not be involved in prohibiting how you practice your faith. The two religion clauses of the First Amendment applied to the states through the 14th Amendment, coupled with the free speech rights, have secured our religious freedom in America. But these clauses, again, have been threatened in the past, and they are being threatened today, I believe. So we talked about the Civil War. Now let's talk about, well, what about freedom between the Civil War and the present? Was there freedom between that time? As we talked about, the Bill of Rights, when it was first written, the First Amendment only applied to acts of Congress, and they didn't apply to actions of the states. That was in order to preserve slavery. Your state could impose a religion on you or take away your freedom of speech. And after the Civil War, when these additional amendments were passed, including the 14th Amendment, they were applied to the states. Now you think that that would be the end of the story, that like Abraham Lincoln said at the Gettysburg Address, the war, and ultimately as a result, restored the idea that all people were created equal, but that's not what happened. After the post-Civil War period of Reconstruction in the South, those in power did not want the former slaves to be able to get ahead and take over the government, so they instituted things like poll taxes and imposed segregation in almost all areas of life. And although slavery was illegal, the people were not treated equally. And states even imposed laws that prohibited interracial marriage and made it hard for minorities to vote. Schools and businesses were segregated. So how does this exist under a constitution? Well, it took a long time because there was nobody up there fighting for the rights of people who were being discriminated against. Ultimately, It took a period of nonviolent resistance and civil disobedience to challenge the segregation laws, and the legislative and legal processes followed that. In 1954, the Supreme Court ruled that school segregation was illegal in a case called Brown versus Board of Education. And on December 1, 1955, Rosa Parks, an African-American seamstress, refused to yield her seat on a segregated bus, and she was arrested. This ultimately led to the Montgomery bus boycott, which led to a federal ruling a year later when the Supreme Court made the decision in Browder versus Gale that bus segregation was unconstitutional. And there were a number of other cases that went forward at that time. It wasn't until 1967 that the Supreme Court ruled that a Virginia law that made it a criminal offense for an interracial couple to marry was unconstitutional in a case called Loving versus Virginia. Up until 1967, it had been a criminal offense. You could go to jail if you were an interracial married couple. And the state of Virginia argued at the Supreme Court that its law against interracial marriage was constitutional because it affected people of all races in the same way. But the court found that the law had no legitimate purpose. Chief Justice Earl Warren said, "Under our Constitution, the freedom to marry or not marry a person of another race resides with the individual and cannot be infringed by the states." So why am I bringing up the civil rights movement in the context of religious liberty? Well, there are two reasons. First, I would submit that religious liberty is a civil right, and that when some civil rights are taken away, all rights are in jeopardy. Secondly, the civil rights movement resulted in Congress passing the Civil Rights Act of 1964, and this provides freedom from religious discrimination in business, housing, and the workplace. Title VII of the Civil Rights Act of 1964 is a federal law that prohibits employers from discriminating against employees on the basis of sex, race, color, national origin, and religion, and it applies to employers with 15 or more employees at the federal, state, and local level. So, because of the civil rights movement, because of what happened in Montgomery, if you are a Seventh-day Adventist who wants to have Sabbath off at work, you can actually assert your rights under the Civil Rights Act of 1964, Title VII. Everything is tied together. And if you claim that the government is establishing religion or is violating your free exercise rights, you have to argue, if you want to get federal jurisdiction, if you want to go to the Supreme Court on the issue, you argue that the court has jurisdiction under the Due Process Clause of the 14th Amendment passed after the Civil War. Again, everything is tied together. That's an important theme to understand because freedom cannot be seen in a vacuum. It all works together. But for freedom to work, it has to work for as many people as possible. Freedom is not only the freedom to be right, but it is also the freedom to be wrong when it comes to matters of faith. So we've talked about the civil rights movement and how it benefited from the actions of those who dared to disobey unjust laws through civil disobedience. And we've talked about how that's worked through the Supreme Court and the Congress. But let's turn our attention to the ways that the Supreme Court has recently interpreted the law. Last week, Justice Antonin Scalia died, and the court has received a lot of attention. As we're going through this election cycle, there's a lot of debate over whether or not President Obama can appoint a successor to Justice Scalia during this cycle. And if you go to religiousliberty.tv, I have a summary of Justice Scalia's opinions on religious liberty issues, and you can go down that list and see what he's had to say about different things and how his rulings have impacted the religious freedom in America. But for now, let's focus on what was happening with religious liberty when it came to the Supreme Court during the Civil Rights era. During the Civil Rights era, 1950s and 1960s, the Supreme Court began to realize that schools had been mainly arranged to support a Protestant religious worldview, and the Bible studies and prayer, while they were fine for the Protestant students, alienated other students of other faiths, and they constituted an impermissible establishment of religion. After all, the schools themselves were taking on the roles that should be reserved to the parents and the churches. So the court heard cases involving school-instituted prayer and Bible studies and found that these practices were unconstitutional. It wasn't unconstitutional for students to choose to pray with each other individually and informally, but it was unconstitutional for the public schools to require students to participate in prayer or Bible study. The court also instituted restrictions on government funding of religious schools, strictly interpreting the free exercise and establishment clauses, and they built up the wall of separation of church and state during those years. But in the late 1970s, a number of religious groups which had felt alienated by the events in the courts began to argue that God had been kicked out of the public schools and therefore out of America, and that the failure of the government to force Americans to follow Christianity through those institutions had led to a national moral decay. By the end of the 1980s, the Supreme Court was taking on a new tone brought by Justice Scalia, who was appointed to the bench in 1986. Perhaps no jurist on the Supreme Court has had the impact on religion and on the religion clauses as much as Justice Scalia did during his 30 years on the bench. In 1990, the Supreme Court heard the case of Employment Division versus Smith, which involved two Native Americans in Oregon who had been denied unemployment benefits because they used peyote as part of their religious services. And one thing that you find out when you study the Supreme Court is that it's a mistake to get caught up in the facts of each case, because you need to see what the overall theme is and what's happening there. I talked about this one time and somebody said, why are you defending the right to use peyote? It's a hallucinogenic. This shouldn't be something you should be concerned about. Obviously, it's illegal, and people who practice that as part of their faith shouldn't receive any benefits. But the way the decision was worded by Justice Scalia was incredibly broad and would apply to a number of people. I'm going to talk briefly in a few minutes about how broadly that could be applied. What Justice Scalia said was that it was unreasonable for every person who had a religious belief that was different from the mainstream to try to get an exemption from a neutral law that was neutral toward their religion and that applied equally to everybody. It was unreasonable to get that kind of an exemption because otherwise you'll have chaos. Everybody will have their own free exercise right to religion, and it's just a luxury that Scalia said it is a luxury that we can no longer afford. Well, after Scalia's decision came out, a lot of religious groups were concerned, not just the people who smoke peyote. Excuse me. They were concerned that now any practice that they did that was against a neutral governmental law could now be prohibited and that the state would not have to require an exemption. So what happened was, in 1993, Congress passed something called the Religious Freedom Restoration Act. It was signed into law by President Clinton, designed to protect religious minority groups who were adversely affected by the decision in Smith. And the Supreme Court reviewed the issue yet again. Excuse me. And ultimately, in two decisions, one of them was Bernie versus Flores, and another decision was a decision having to do with the Church of the Vegetable, which was a marijuana church. They decided that the Religious Freedom Restoration Act would only apply to federal actions and not to state actions. Therefore, a state can still pass a law that will adversely affect your religious free exercise, but the federal government cannot. And in 1992, the Supreme Court heard another case called Lee versus Weissman. Employment Division versus Smith dealt with the free exercise clause. Lee versus Weissman dealt with the establishment clause. In that case, the court ruled that public schools may not sponsor clerics or pastors to conduct non-denominational prayer. In that case, the court found that the state acting through schools was coercing students to face a social dilemma of either participating or protesting a prayer that they disagreed with. And Justice Kennedy wrote, "The embarrassment and intrusion of the religious exercise cannot be refuted by arguing that the prayers are of a de minimis character, since that is an affront to the rabbi," there's a rabbi who'd wanted to offer the prayer, "and for those for whom the prayers have meaning, and since any intrusion was both real and a violation of the objector's rights." In other words, it would be, when you have students, you have a captive audience, and you can't impose your religion on them. But in Scalia's view, he wrote a lengthy dissent to that decision. He said that the only way that the government could really violate the Establishment Clause would be if the government punished people actively for not participating in a governmental religious practice. So the majority in the court had applied what was known as the coercion test, and Scalia said that that test was unreasonable. Thank you so much. And so Scalia's position on that issue was very contrary to the majority on that decision. But ultimately, he believed that the Establishment Clause was much weaker than the rest of the court did. Well, then, fast forward to 2014, and the Supreme Court looks at the case of Hobby Lobby. Has anybody heard about that case? Yes. Now, the Supreme Court applied the Religious Freedom Restoration Act, which had only applied to actions of the federal government, to Hobby Lobby, and said that Hobby Lobby itself had which is a large corporation with tens of thousands of employees, that said that they were a closely held corporation because it was owned by only a few people, and that their religious views could allow Hobby Lobby to be excused from the federal Affordable Care Act, or Obamacare, when it came to provision of contraception to employees. So now the Religious Freedom Restoration Act, passed in 1993, intended to help minorities, was being applied to a large corporation with tens of thousands of employees, and being used to prohibit or to allow the corporation to not provide the services to the employees. It was really a much broader application of RFRA, which I believe ultimately could damage the Religious Freedom Restoration Act because it's being stretched so far out. And in 2015, the Supreme Court extended the reasoning in the Loving versus Virginia case, which was the interracial marriage case from 1967, and applied it to same-sex couples who could now marry each other after this decision in the Obergefell versus Hodges case. Now, the Obergefell case presents a very special challenge, because now same-sex couples have a constitutional right to marry. That's part of the law. Yet there are also people who have a right to free exercise of religion who disagree with same-sex marriage, and they don't want to participate in those services. It's creating a very difficult dilemma for a number of constitutional scholars, because they're saying, well, this is going to have to go through litigation, and the same-sex marriage advocates are going to have to fight the religious advocates, and ultimately one of them is going to win and the other one's going to lose. And I can predict that if that process takes place, there's going to be a lot of litigation, a lot of legislation going back and forth both ways, and nobody really knows how that issue will resolve itself. The Constitution, before I talk about my solution to that, possible solution to that problem, the Constitution and the way that the United States is set up ultimately, again, protects the right to be wrong. And these scenarios have created a very real dilemma. In Oregon, the owners of the Sweet Cakes Bakery were fined $135,000 for circumstances involving their refusal to provide a cake for a same-sex commitment ceremony. In Kentucky, a t-shirt printer, Hands On Originals, was fined for refusing to print shirts for a 2012 Gay Pride Festival. And in Hobby Lobby, and the issues would still apply, you have the religious exercise rights of the owners versus the access rights of the employees. Interestingly, small businesses in states without the Religious Freedom Restoration Act are still subject to those limitations of Employment Division versus Smith. So if a state were to enact a contraception mandate, the owners of those corporations would not be protected under the Religious Freedom Restoration Act like Hobby Lobby was. So the courts have been looking at these issues, and one very interesting case went all the way to the New Mexico Supreme Court involving a couple that owns a wedding photography company called Elaine Photography. They were fined for refusing on religious grounds to photograph a same-sex commitment ceremony. And Judge Richard Bosson of the New Mexico Supreme Court, in his ruling in the case of Elaine Photography versus Willick, said when it came to the question of who should prevail when civil rights and free exercise intersect, that civil rights should beat free exercise. He said that that type of compromise is ultimately the price of citizenship. And told the photographers, well, you have no rights in this situation. Then you have cases where accommodation is almost impossible. You have the Little Sisters of the Poor Home for the Aged versus Burwell, which is going to be heard before the Supreme Court on March 26. And in that case, the nonprofit religious employer is invoking the Religious Freedom Restoration Act on its behalf to make an argument. They're taking Hobby Lobby even further by saying that even by advising employees that they could go elsewhere for contraceptive coverage, that violates their religious beliefs and their rights, and therefore they should not have to even take that additional step. It's almost essentially impossible to accommodate that type of situation. And there's the case of Kim Davis in County, who argued that she should be allowed to exclude same-sex couples from licensing because those couples could go to other counties nearby and obtain the licensing. They didn't have to get them from her. Those are also issues, another case where it'd be very difficult to find an accommodation. So under the current rules of engagement, when moral absolutes conflict with protected rights, the sides prepare for battle, and too often, one side goes to court and the other goes to the legislature, and both seek the political advantage. These battles result in successive chains of clear winners and losers whose fortunes can be reversed easily in the ensuing rounds. With respect to the conflict of sexual orientation versus religion, or reproductive rights versus institutional rights, those involved see their positions as a defense of their own identity. And without an amicable resolution, a fight can ensue. If it is resolved legally, by necessity, one right will be ranked above the other right, and one side will be forced to do something they believe is wrong, or will be forced to forfeit a civil right. There will always be those who take the spotlight as they argue their competing claims of morality, but they are a distinct minority and most simply want to get things done, make some money, or order a cake without surrendering their constitutional rights or violating their religious beliefs. There are rights that can be asserted legally and socially, and simply giving up your rights is not acceptable. But I believe that asserting one's rights should not necessitate a call to arms. Instead, and this is something I've been working on with some attorney groups, the idea that I would propose is that alternative dispute resolution methods be applied before specific disputes arise to encourage and facilitate cooperative dialogue between representatives of major competing interest groups. By appreciating the sincerity of different viewpoints, while at the same time recognizing that many are mutually exclusive, a summit of respected representatives from competing interest and advocacy groups working in the spirit of goodwill could develop a matrix of practical possibilities for accommodations and compromise points. Practical steps when you bring these groups together would be taking an inventory of differences, identifying ideas on which neither side will compromise, assessing practical concerns, developing provisional agreements, and testing them with potential scenarios. Ultimately, the representatives of each side would be able to achieve agreements in advance with respect to how they would approach the issues if they arise in the future. This type of a framework would not necessarily work for the all or nothing ideological poles of the debate. There will always be people on both sides who want to make their point at any cost, and these groups likely will exclude themselves from any preemptive negotiation process. For example, in the Affordable Care Act arenas and those cases, the corporations or institutions demand for accommodation in the name of free exercise of religion without willingness to even listen to other options could result in a classic Establishment Clause violation. In such cases, those who were exempted from the laws would put the cost on the taxpayers who practice other religions or none at all. So in the Affordable Care Act, they can't simply put the cost on other people because that could violate the Establishment Clause. But one thing is clear, there's a tension between the Establishment Clause and the Free Exercise Clause. And that tension is fluid and goes from side to side. So I'm not proposing this as a constitutional argument, but rather as an informal resolution of the issues that would be peaceful and pragmatic. This would not be a workable concept for the county clerk in Kentucky or for the Little Sisters of the Poor who insist on an all or nothing approach. Instead, it is a play in the joints approach. Play in the joints was the term used by Justice Ginsburg in the Cutter case, that would set aside the politicians, the courts, and the legislatures and their imperfect and protracted solutions, and instead address the mainstream ordinary disputes that arise when a person asserts a simple right. Under this concept, each case would be evaluated in its own circumstances and in its own merits, and the parties would not be on a fact-finding mission to win later litigation, but rather to resolve the case in a very practical way. So how does this work? There are several methods for this. First would be to seek to understand the motivations and encourage the dialogue between the sides, so that each could present their viewpoint fully without being judged. Each side could present their ideological perspective during this step, but to succeed they would need to do so with the goal of increasing understanding rather than simply beating the other side. Further, each side can discuss religious beliefs, their histories, how it previously resolved these types of disputes, etc. Now remember, we're in a constitutional situation where both sides have rights. So you cannot legally discount a side's rights completely. That would require reversal at the Supreme Court level, which is not likely to happen. So this is why I'm proposing a more pragmatic, practical, on-the-ground approach. Next step would be to develop a list of practical, not ideological issues that must be addressed cooperatively. Things like a timeline for addressing the issues. For example, in the wedding cake case, figuring out how to order the cake, who to refer people to, so there would be a seamless process for both sides involved. Determine what issues both sides could stipulate to and exclude them from the dispute. If you agree with somebody on something, then that's off the table. We already agree on that issue. Where is the issue of dispute? And determine what areas still remain in contention and focus on them so that you have as specific an area of contention as possible. Propose specific practical alternatives to the issues that remain. Both sides should perceive and work that they are working cooperatively to try to find a way to resolve the issues. Isolate irreconcilable issues that cannot be resolved, and work to resolve those issues or to develop alternative accommodations. And ultimately, develop narrowly tailored accommodations that can resolve the dispute practically and peacefully between the sides. So in other words, instead of engaging in a large ideological battle, this would be focused on the very nature of the dispute and finding a very clear final solution to address the issue. By recognizing the sincerity of the opposing positions on the issues and deriving specific areas of accommodation, the conversation moves from ideology and conflict to one of mutual and practical problem solving. One way that this can be accomplished, so you have this type of system, is to hold summits between major advocacy groups on all sides to promote the approach by demonstrating the cost and the risk of litigation and the unpredictability of the political process. In other words, it's really the only option unless you want to go to war. Obtain consensus to participate in multicultural problem-solving exercises. And by multicultural, I mean an understanding that not everybody will agree on everything. You may have a complete understanding on your side, you may have a complete understanding on your side, but you still need to work to resolve the issue that's before you. And during those types of meetings, you could address hypothetical scenarios and develop those mutual solutions. And ultimately, you could have standing bilateral committees that could be convened to address those issues. That way, when an actual conflict emerged, key negotiators would be able to meet with the parties involved and develop the practical framework based on what they've already developed and identify the areas of concern and then meet and confer to attempt to find a resolution. And if no mutual solution was reached early on, then they could offer mediation with the participation of the parties and the key negotiators for each side. The goal of this problem-solving approach would not be to win, but rather to resolve the problem and move forward as quickly and painlessly as possible using the framework as a point of reference. Now, I realize that there are some who think that even conceiving of such a dialogue is heretical, and that nothing short of winning the battle for godliness in the courts and forcing beliefs on others is acceptable. But at the same time, I would propose that the Apostle Paul provides us with a more tangible alternative, and that Romans 12 can provide a model for cooperative conclusion that would work in 80 to 90% of the cases. Under this model of engagement, the right to hold one's faith is validated, and the right to not hold that faith is also validated. People are still able to live their lives and avoid persecuting the other side, and avoid those types of conflicts that would simply drive the other side further away from God rather than toward God. In a recent speech, Elder Dallin Oaks of the Church of Latter-day Saints described this type of approach when he said, "My thesis is that we all want to live together in happiness, harmony, and peace. To achieve that common goal, and for all contending parties to achieve their most important personal goals, we must learn and practice mutual respect for others whose beliefs, values, and behaviors differ from their own. As Justice Oliver Wendell Holmes observed, the Constitution is made for people of fundamentally differing views. Differences on precious fundamentals are with us forever. We must not let them disable our democracy or cripple our society. This does not anticipate that we will deny or abandon our differences, but that we will learn to live with those laws, institutions, and persons who do not share them. We may have cultural differences, but we should not have culture wars." Ellen White wrote something similar in 1866 in the Sabbath School Worker, when she said, "One grand lesson that should be taught to our children, and that is freedom from every particle of egotism and bigotry. They should be taught that other souls outside of our faith are precious, and that jesting, sneering, sarcasm, or contempt for those outside of our faith will be an offense to God. Such a course will wound the soul, hinder the prayers, and enfeeble the spiritual growth of those who indulge in them. We should educate the children not to be narrow but broad. Finally, as Paul writes in Romans 12:18, if it is possible, as far as it depends on you, live at peace with everyone." Amen. Okay. Let us pray. Dear Heavenly Father, we face challenges in this country when it comes to religious liberty. We face challenges as to how liberties will be stacked up against each other and who will ultimately win. And we know that you are ultimately in charge. Please grant us wisdom as we go through these next years and through this election cycle, that we can stay true to you above all else. In Jesus' name, amen.